Let me know when we're on YouTube.
I believe we're streaming now.
We're on, Judge.
All right. Court will continue then. We'll come back to order on State versus Mr. Sanchez. State, call your next witness.
State calls Janine DeKing.
Ms. DeKing. Ms. Janine DeKing.
Hello, I'm here.
Here you are. Good afternoon. The state has called you as a witness. Would you raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, ma'am. You may put your hand down. Your witness, Mr. Edelman.
Hello, ma'am. Would you please state your name and spell it for the record?
Yes, my name is Janine DeKing, Janine, last name Deking.
Thank you. What is your occupation?
I'm a senior analyst at Quality Forensic Toxicology
And how long have you been employed there?
for 4 years.
I'm sorry, Mr. Edelman, can I interrupt you for a minute?
Please do.
Is this going to be the witness to lay the predicate for the lab results?
Correct.
And I'm assuming that you're going to list that as State's Exhibit 6?
I sure would like to.
Okay. Your Honor, if the state is okay with it, I'm okay with waiving the predicate and no objections to State's Exhibit 6 if we can proceed that way.
I have no objection to that, Your Honor.
State's exhibit. Okay, the court first notes that the defense has no objection to the to not laying the predicate for State's Exhibit 6, and has no objection to State's Exhibit 6. Therefore, State's Exhibit 6 is admitted. You may proceed, Mr. Edelman.
Ms. Rivera, I have uploaded State's Exhibit 6 to the offered by state folder. If you will refresh your screen.
Yes, sure will.
Very good.
So Ms. DeKing, this,
Wait. Ms. Rivera, are we ready to proceed?
Yes, sir. Thank you.
All right. Proceed, Mr. Edelman.
Ms. DeKing, this will be rather abbreviated because of the circumstances, but could you briefly describe to the court your credentials and experience?
Yes, I have a bachelor's degree in biology from the University of Texas at San Antonio, and I have postgraduate training in forensic toxicology from the University of Texas Health Science Center at San Antonio. And I worked in the medical examiner's office as a toxicology chemist and senior toxicologist for 8 years prior to starting here as a senior analyst with quality forensic toxicology. I'm currently licensed in the state of Texas to testify about interpretive toxicology, and I am certified by the American Board of Forensic Toxicologists as a forensic toxicologist.
And the lab where the analysis of the blood samples relating to this case were conducted, was that, my apologies, was that an accredited lab?
We are accredited by A2LA.
And can you tell the court when the lab was accredited?
In 2017,
And was it accredited at the time of the analysis of the specimen?
it was.
Your Honor, I would like to publish State's Exhibit 6.
No objection from the defense.
No objections, Your Honor.
You may publish.
Thank you, sir. Ms. DeKing, would you please tell the court what this document is?
This is a final report for a forensic toxicology test we performed for an alcohol concentration.
And who is the subject?
The subject is Christopher Sanchez, born
And-
10/18 of 92.
Thank you. Can you briefly tell the court what the analysis indicated to you?
We performed a Headspace GC blood alcohol test, and we achieved a concentration of ethanol at a 0.214 gram per deciliter result.
And just out of an abundance of caution, could you briefly describe to the court, if you can, the condition of the blood sample when it arrived at your lab?
So I would note on my batch list if the sample was in any sort of errant condition like blood clots noted or anything along that lines, and I have nothing noted for this sample, so it would have been in good working condition.
So it's your testimony that based off of this analysis, the blood alcohol concentration for Christopher Sanchez with a date of birth of 10/18/1992, at the time of the draw, September 16th, 2018, at 4:44 a.m. was 0.214 grams per deciliter?
Yes,
And is that above the 0.08 legal limit?
it is.
Pass the witness.
Good afternoon, Mr. King. I just have a very short examination. Were you present on the night of arrest of September 16, 2018?
I was not.
Okay, do you have any information concerning the surroundings of why my client was operating a motor vehicle?
I do not.
Pass the witness.
No further questions, Your Honor.
May the witness be excused.
Thank you.
With the court's permission,
Yes, I'm okay with the witness being excused, Your Honor.
Ms. The King, is it capital D,
Yes, sir.
lowercase e, then capital K?
Yes, sir.
So it's the King.
De King.
Thank you, ma'am. We appreciate your presence and your testimony. You're not
Thank you.
excused. You're free to go for the day.
Okay, thank you.
You're welcome.
and Your Honor, may I stop sharing the screen?
Yes, of course.
Thank you, sir.
Call your next witness, Mr. Edelman.
At this time, the state has no further witnesses to call.
Do you rest?
State rests.
Ms. Gonzalez, call your witness.
Actually, Your Honor, since I reserved my right for opening, may I proceed with a brief opening?
Of course you may.
Thank you, Your Honor. Your Honor, as you've heard through the testimony of the state's witnesses, there is no question before the court as to whether my client was operating a motor vehicle and whether or not he was intoxicated while he was doing that. As required by the necessity, provision, and justification in the code, the penal code, and from the case law that came out of cases, he will be taking the stand and he will admit to each and every one of the elements that the prosecutor has charged my client with. He will testify to operating his truck. He was driving home. It happened on September 16th, 2018, and he will admit to the court he was intoxicated. From all of that, we do know what the what is before the court, but that's not the question. The question before the court is the reason why it was happening. Even with Officer Zimmerman testifying, Officer Zimmerman even stated he did not do a thorough investigation with regards to that. However, my client will be taking the stand and will explain to the court what he remembers from happening that night, the assault that he felt, and the danger that he felt, and why it was that he felt the need to get into his car and drive at that point in time. So with that, Your Honor, I do rest and I'm ready to call my first witness.
Very good. Call your witness.
I call Devin Ruescher, R-U-E-S-C-H-E-R.
Devin Ruescher. Patricia, bring them in on the computer.
He's there, Judge.
Witness room.
Yes, sir.
Mr. Devin Ruescher, would you please raise your right hand? Your other right. Mr. Bellow, are you unable to raise your hand, sir?
No, my hand's right. Right hand.
I'm sorry?
It's my right hand.
It is your right hand? We have an anomaly here. From the appearance to the court, you're holding your left hand up.
And Your Honor, if I may clarify for the record, that's the way it looks on my side, but there is an option with the video to change and flip the feed. So
Okay.
it is possible that he's holding up his right hand.
Mr. Bellevue. Is Mr. Bellevue present?
Yes, I'm right here, Your Honor.
All right, can you, as an officer of the court, can you aver that Mr. Ruescher has his right hand up?
Yes, he has his right hand up.
Okay, I'll certainly take your word for it then. Mr. Devin, is it Ruescher?
Yes, sir.
Yes, sir. Would you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You may put your hand down. Ms. Gonzalez, your witness.
Thank you, Your Honor.
Excuse me, I'm having a hard time hearing him. Maybe he can scoot closer to the computer.
You're having a hard time hearing whom?
The witness, he just
Okay.
scooted closer, so hopefully that'll work.
Would you say something, Mr. Ruescher?
Yes, sir. Sorry, I'm a soft-spoken person.
That's
Okay.
nothing to be sorry for, but we appreciate your being here to testify, Randy. All right, you may proceed, Ms. Gonzalez.
Thank you, Your Honor. Now, Mr. Ruescher, can you please spell your name for the record?
D-E-N-R-U-E-S-C-H-E-R.
Thank you. And because I'm not familiar with you, can you go ahead and pronounce it for me?
Devon Ruescher.
I apologize for the way that I was pronouncing it, Mr. Ruescher.
No problem.
Now, can you please tell the court what it is your profession is?
I'm a level 3 private security officer.
And what does that mean?
I'm an armed security officer, and level 2 is unarmed.
Okay, and what are you armed with?
Firearm, Glock.
Okay, did you say a firearm and a Glock?
Glock is the firearm. I basically look like a cop without being a cop. I
Okay,
have almost every bit of equipment they have.
so for instance, pepper spray, do you sometimes carry pepper spray when you're on duty?
Every time I'm at work, I carry pepper spray.
And that is one of the things that you're licensed for, correct?
Yes, ma'am.
And back in 2018, actually, let me go ahead and ask you, have we ever met before?
No, ma'am.
Okay, have we ever spoken before?
No, ma'am.
Do you honestly have any real understanding of what's going on here and why you've been called before the court?
Not 100%.
Okay, let me go ahead and take you back to September 2018. Were you also a licensed security at that point in time?
Yes, ma'am. I've been a licensed security officer for the past 6 years.
And at that time, were you also a level 3?
Yes, ma'am.
And do you remember where, were you working for a private company?
Yes, ma'am.
What was the company at that point in time?
DFW Security Services.
Is that D as in dog?
Yes, ma'am. Dallas Fort Worth Security Services.
Okay. And did that put you working here in San Antonio, Texas?
Yes. Most of the jobs we had were in San Antonio.
And do you remember working on the North St. Mary's Strip back in 2018?
Yes, ma'am.
And how would you describe the St. Mary's Strip that I'm talking about where you're working?
It's the bar strip where I was at. There were 3 bars nearby that we worked. There were more, but there was only 3 that we actually worked in that location.
Okay, and what 3 bars, if you remember, were at that specific area?
The only 2 I know the name of is Squeeze Box and La Botanica.
Squeeze Box and La Botanica?
Yes, ma'am. The other one, it's a weird name, so I can't remember it.
Okay. And what were you working inside at that time, or do you work outside?
I was working the front door.
Okay. And you already stated that you are licensed to be armed, and you did carry mace at that point in time.
Yes, I do carry pepper spray.
Do you remember working that night, the night of September 15th and 16th, where there was a boxing match?
Don't recall a boxing match.
Okay. Is it possible that the bar that you were actually working at La Botanica did not air that boxing match?
They did not.
So, but you were working on September 15th, that overnight shift, right?
I worked, I think that was 9 to 2 at that location.
Okay. Do you remember being at La Botanica at the door and seeing a actual physical fight with people?
Yes, ma'am.
Okay. Can you tell the court what you remember?
Doing my job at the front door. I have a few straight view across the street where the fight was happening. It was 5 to 6 guys fighting. One guy, I didn't know who he was. It looked like it was going to get really bad, so I intervened with pepper spray. And as soon as I sprayed, I asked everybody if they needed assistance, but they all scattered like cockroaches.
Did you just say scattered like cockroaches?
Yes, ma'am.
I love it. That is a great description of it. So when you said that it was about 5 to 6 guys, well, actually, let me ask you, if you can take a look at the screen, do you recognize any one of those guys from that night? Do you recognize them on the screen?
No, ma'am.
Okay. Do you recognize my client? He's labeled Christopher Sanchez. Do you recognize him?
I do remember him. He was a regular on St. Mary's.
Okay. And do you remember him being a part of this group of people fighting?
No, ma'am, I don't remember exactly who was the initial one getting attacked, but I sprayed because it was 5 to 6 guys and I'm one person. I'm 120 pounds at the most. There's no way I was going to break that up.
Sure. And when you say it was 5 to 6, from what it appeared to you, did it look like it was 2 people versus a group of 3 people? Or did it look like 1 versus 4 people?
From where I was standing, it looked about 1 against 4 or 5.
Okay, and you said that you recognized my client, Mr. Sanchez, from being a regular in that area, right?
Yes.
Do you remember having a conversation with him after this fight, this physical fight that you witnessed? Do you remember having a conversation with him in December of that year saying, hey man, I recognize you from that fight? Do you remember that conversation?
No, ma'am.
Now, let's go ahead and go into a little bit more detail about the fight. You said it looked like it was going to get really, really bad, right?
Yes, ma'am.
When you sprayed that, it actually required you to use, what did you call it? Pepper spray?
Pepper spray.
Okay, and you stated, how much do you weigh?
About 120, 130 pounds.
Okay, so even you, did you get a little bit of training for your job?
I have quite a bit of training.
Okay, so even with your extensive training, quite a bit of training, you felt the need to use a spray to get people to disperse, right?
Objection, leading.
I can rephrase, Your Honor.
Please
Sir, did you feel like it was dangerous at that point in time?
Yes, ma'am.
Okay. And so you felt it was dangerous enough to be able to use a spray, right?
Yes, ma'am.
And then you said they scattered like cockroaches, right?
Yes, ma'am.
You said it was about 4 or 5 guys looking like it was on one guy. Did you see where those 4 or 5 guys went?
No, ma'am.
Did you see where any of them went?
No, ma'am.
And the one person that was there that looked like they were being attacked, did you see that person having any friends or anybody around else other than you that was helping that person?
No, ma'am.
And then when you say attacked, can you describe from what you remember, if you remember anything? Can you describe any of the details of the attack?
It basically looked like 4 or 5 guys pummeling a guy on the sidewalk, on the ground.
Okay, so my client was actually on the ground.
Yes, ma'am.
Objection. The witness is not, to my knowledge, identified Mr. Sanchez as the person who was being struck.
I can rephrase, Your Honor.
The objection sustained. You rephrase, ma'am.
Okay, the person you saw that was being attacked, that person was on the ground, right?
Yes, ma'am.
And attacked by multiple people. How were they attacking that person?
Punching, kicking, stomping.
I'm sorry, the last one, punching, kicking, what?
Stomping.
Okay.
Now you said they scattered like cockroaches. You didn't see where those 4 or 5 guys went?
They all went in different directions.
Okay. When you were standing there, did you see anybody else remaining there?
No, ma'am.
Okay. I'll pass the witness, Your Honor.
Your Honor, may I proceed?
Yes, you may.
Thank you, sir. Mr. Rusher, good afternoon. Did I pronounce your name correctly?
Yes, sir.
Okay, good. When did you first become aware of this altercation that gained your attention?
I couldn't tell you the time.
Can you tell the court what it was about this altercation that aroused your attention?
I work at the front door. I'm usually staring straight out to the street. A group of people were walking and then a fight broke out. I was watching.
I'm sorry if I interrupted you.
Our policy is we don't get involved in anything off our property unless it is a felony in our view or if they're in immediate life-threatening danger.
And so you believe that whoever was the victim of this assault was in immediate life-threatening danger, or it was a felon?
Yes, sir.
But you did not see the manner in which this fight began?
No, sir.
And so you did not see if the person who was being assaulted had done anything to provoke that assault, did you?
No, sir.
Now, when you used your, is it more appropriate to call it pepper spray or mace?
It's pepper spray.
When you used your pepper spray, the assailants fled in different directions.
Yes, sir.
Can you tell the court approximately how long you remained at the scene, if you recall?
It wasn't more than a few moments after I sprayed because everybody ran off. So I went back to my job site, which was right across the street.
Did you see where the victim of that assault went?
No, sir.
Now, were you able to still see the area where the assault occurred after the assailants had fled?
Yes, sir.
Did any of them return, if you remember?
Not to my knowledge. I don't remember.
So once they fled, as far as you remember, they did not return.
Yes, sir.
Nothing further, Your Honor. Pass the witness.
Just a brief follow-up, Your Honor. Sir, after you returned back across the street to your job site, how late did you stay there? What time did you leave?
If I can remember correctly, I think that one stopped at 2:30 or 3 o'clock in the morning.
And while you were there, did you see any officers or anybody else come by to do an investigation or see what happened with this assault?
Objection, relevance.
No, ma'am.
Sorry, sir.
Hold on.
I'm thinking.
Hold on. All right. The objection is relevance to asking if he saw any officers appear on the scene.
Correct, sir.
I'll overrule that. And
Now
he's-
you may answer, sir.
No, ma'am. I didn't see any police officers or any other security officers show up.
And just to clarify again, you felt your job site rules said that you're not allowed to go off the property unless you saw a felony. Did you see anything that appeared to you to be aggravated bodily injury? Was the person that was the victim, was he able to get up and run away?
Yes, ma'am.
Okay. So the other reason that you had was if a person's life was immediately in life-threatening danger, correct?
Yes, ma'am.
Thank you. I'll pass the witness.
Mr. Rusher, if you remember, did the victim of that assault ask you for any further assistance?
Not to my knowledge.
Didn't ask you to call the police for them?
No.
Didn't ask for you to provide medical attention?
Nope.
Didn't ask you to provide any further protection for them?
No, sir.
Didn't ask you to call any authorities at all?
No, sir.
Thank you, Your Honor. Pass the witness.
No more questions, Your Honor.
May the witness be excused.
I am okay with excusing this witness, Your Honor.
Mr. Edelman.
I'm fine with it, sir.
All right. Mr. Rusher, we thank you for coming in. You are excused. You're free to go. Mr. Bellabo, thank you for your assistance.
He is released from his subpoena, correct?
I'm sorry?
He is released from his subpoena at this point.
He is, absolutely.
All right, thank you, Judge.
Thank you. Happy New Year to you guys. Ms. Gonzalez, next witness.
Thank you, Your Honor. I now call my client, Christopher Sanchez, to the stand, to the remote virtual stand.
Mr. Sanchez, raise your right hand. You solemnly swear that testimony you will give will be, or materials you submit, if any, will be the truth, the whole truth, and nothing but truth to help you God.
Yes.
Pardon me?
Yes, Your Honor.
All right, now put your hand down. Mr. Sanchez, just for the record, I inform you and remind you, I'm sure your attorney has done it already, but for the record, You have the right to remain silent. That means you do not have to testify. You do not have to make a statement. You do not have to submit any paperwork. Do you understand you have that right?
Yes, Your Honor.
And you're willing to give up that right at this time, and since you are being called as a witness by your defense attorney.
Yes, Your Honor.
All right. Ms. Gonzalez, you may proceed.
Thank you, Your Honor. Christopher, can you go ahead and introduce yourself to the court?
My name is Christopher Sanchez.
And do you reside here in San Antonio?
I live here in San Antonio, Texas at 302 Adaes Avenue.
Okay.
And I am.
And go ahead. Sorry, I'm sorry.
No.
Now, were you the person that was arrested on September 16th?
Yes.
Can you please describe to the court why you were out that evening?
Just going out to go watch the fight, this boxing fight.
And please tell us a little bit more from what you remember about the boxing fight. Who were the participants?
The participants was Canelo and Triple G. I can't really pronounce his name, but those are two major fighters. It was just for a championship. It was a really big event.
Okay. And did you go out that evening with any friends?
Yes, I went out with one friend of mine. His name is Steven Gonzalez.
Okay.
And then later on, I met one of our friends at the very end of the night came. His name was Joel Sarabia. He came at the end. So I was hanging out with three of my friends.
And do you remember previously testifying before this court?
Yes.
And when you testified during one of those hearings, did you previously give these two names in your testimony?
Yes.
And at those hearings, was Mr. Edelman, the prosecutor, questioning you when you gave those names to the court?
Yes.
Now, were you out drinking that night?
Yes.
How did you get to the bar?
I drove my truck.
And what type of vehicle is that?
I drove, it's a white Chevy 2005 pickup truck.
And is that the vehicle that we saw in the video?
Yes.
Now, did you intend to go out drinking that night?
Just actually not to that extent, but it just, it just happened. I guess you just forget.
Now, while you were there and you had been drinking, did you realize that you were too intoxicated to drive?
Yes, after we had a walk, yeah, we realized it, so we called another friend of ours to come through us, come pick us up.
Okay, and was that supposed to be your sobered ride?
Yes.
And which one of those friends was the sober driver?
Joel Sarabia.
And what bar was this at?
This one was El Ojo, which was at the very last bar on the strip.
Can you spell that for the record?
ELOJO. No, yeah, Ojo. Oh, yeah, I think that's how you spell it.
El ojo,
Yes, El Ojo.
the eye.
Yes.
Yes. Thank you, Judge. So when you were out that night, where had you parked your vehicle?
I parked it right directly in front of Squeezebox.
Okay, what street would that have been on?
That would be on St. Mary's. It was facing towards 1604. No, sorry, 281.
And from what you remember, when you guys had walked outside the bar, where had your friends parked their vehicle?
Right directly behind the bar. And the bar had a parking lot right behind. So they took a left and I went straight towards Squeezebox, which.
And from what do you remember happening that night?
I was just walking, and next you know, I just hear someone shout out like, F the Triple G, which is the shirt that I was wearing, and then I just get hit on the back of the head. Someone just hits my feet. I fall to the floor, and I just started getting hit everywhere.
When you say that you fell to the floor, I'm sorry to interrupt you, but when you say that you fell to the floor, did you fall forward so that you were laying on your stomach?
I fell forward, and I just pretty much like just kind of somewhat huddled as best as I could, but I was pretty much on belly flat.
And do you remember how many people it was that were attacking you?
Not at the moment. I just felt hits from the head all the way to my feet, so I knew it was more than 3 or 4 people, and it was just everywhere from right, left, back, forward. Like, it was just insane.
When this happened, did you know where those 2 friends of yours were?
I knew they were just behind their truck because I was walking to my truck to get a jacket. That's the only reason I walked to my truck, because it was just right
Getting
there.
your jacket.
Because it was really cold that night and it started to sleet, and that's the only jacket I had.
Okay, so were you guys in the same location when this happened, or in a different location?
Different location. They were behind the bar in the parking lot, and I was walking down the street, maybe a block away from where they were at. So they had no visual on me.
So is it fair to say that you were by yourself when these guys assaulted you?
Yes, I was by myself.
And when you were laying on the ground, did you feel like you were in danger?
Yes, I couldn't believe it. Everything just hurt. It was insane.
And what is the next thing that you remember from when you were on the ground?
I just remember somehow I just somehow like fought my way up. I just got up and just started running. Somehow I just miraculously got up. I don't know how it happened. I didn't even turn back. I just looked to where my truck was, and it just ran. That was it.
Did you ever become afraid that anybody was following you?
Yeah, I really did. The whole time I was running, I thought someone was right. I really look at everyone who was around me. I thought they were after me. I thought someone was after me the whole time.
And what happened when you got to your truck?
I just got in, turned it on, and I got out and I took the first left, and I started heading towards Jermick Mullen, and then head to Woodlawn, and went all the way up Woodlawn, and then once I got to the access road, on the side of the highway to get to Culebra. I was just trying to get home.
Why were you trying to go home?
Because that's the only safe place I knew in my head. I had no other place in my mind where to go. The only place for me was safe was there.
Now, who else would have been at your home?
My whole family was there. My brother, my sister, her husband, my dad, my mom.
So if anybody had been chasing you, did you feel like that would have been a safe place for you to stop your vehicle?
Yes, it's the only place.
Now, did you suffer any injuries after this assault?
Yeah, for about a week or so, I started getting like lightheadedness, just throbbing. I already get random headaches, and head rushes too. I'd get up so fast, just get dizzy really quick.
Did you have any bruisings or cuts, or the officer described lacerations?
Yes. I had bruises for weeks. They wouldn't go away. I had bruises all over my face, my body, my knees. I had scars on my head. I still have scars to this day. Just swelling of the face for a good while.
Now, did you ever go get medical treatment?
No, I don't have medical insurance. So for me to do something like that, it's the reason I didn't go. If I did, I would definitely have gone, especially that night.
But you healed eventually from your injuries,
Yes,
right?
Yes.
Did you have any pictures or take any pictures yourself of any injuries?
Yes, right when I got released, and went home, I took pictures immediately.
And Your Honor, I have marked defense exhibits 1 through 9. Andrew, do you remember from the hearing defense exhibits 1 through 9, or do you need me to email them to you?
I don't recall them, but I also am not entirely certain that you need to email them to me if they are photographs.
Well, I would just need to tender them to you so you can review them for any objections.
if they were taken by Mr. Sanchez.
Correct. I can continue
And-
with my predicate if you want me to now.
Please continue with the predicate.
Okay. Sir, have you reviewed defense exhibits 1 through 9 with me previously?
Yes.
And do you recognize defense exhibits 1 through 9?
Yes.
Now, 8 of the exhibits, those pictures, when were they taken?
Right after I got released from jail, from the holding cell.
And was there another one of the pictures that was taken a few days later?
I took another photo of the worst one a week after that just still stayed.
And are these photographs a fair and accurate representation of your injuries from when you were assaulted on September 16th, 2018?
Yes.
I would now offer defense exhibits 1 through 9 into evidence, absent any objections from the state.
Your Honor, I do object. I believe that the exhibits that their probative value would be significantly outweighed by the potential prejudice.
The photos would be prejudicial, you say?
That their probative value would be significantly outweighed by the danger of unfair prejudice.
And Your Honor, if the court needs me to respond, I can.
I'm going to overrule the objection.
Okay, thank you, Your Honor.
And that's the only objection that I have, Your Honor. The predicate's been laid properly.
All right, well, did I hear you ask if they were fair and accurate representation?
Yes, Your Honor, I apologize. Yes, Your Honor, that was my last question.
Okay. Then the defense exhibits 1 through 9 are admitted. You may publish.
Thank you, Your Honor. Now, Kayleen, I've gone ahead and uploaded them already. Do you mind if I just do my screen share to show them? I already have them marked on the actual photograph, so we don't need to take the time to do that part now. Do you mind if I just go ahead and publish, Your Honor, if you mind if I go ahead and publish straight from my screen share?
I have granted you that permission already.
Okay, thank you, Your Honor. Okay, can everybody see, it should be on the screen right now that says Defense Exhibit 1. Can everybody see that?
Most importantly, I can.
Okay. Now, Christopher, do you see Defense Exhibit 1?
Yes.
Okay. What sort of injuries did you have that you were trying to show from this picture?
The head wound to the forehead, that's where I had got cut. The nose and the swelling, my cheek, just the swelling of my forehead and my face and the bruise.
Now, do you know, did you break your nose or did you suspect that you possibly broke your nose from this assault?
I feel like I did. It was pretty swollen for a couple weeks actually.
Okay.
Very simple.
One moment, Your Honor. Okay, Defense Exhibit 2, is this the other side of your head with the injuries?
Correct.
Now, Defense Exhibit 3, did you get a busted lip?
Yes, I got a busted lip from the inside as well, carried on.
And is that Defense Exhibit number 4?
Yes.
Now, Defense Exhibit number 5, is this the picture that was taken
No.
immediately
No,
after booking?
Yes, that one is immediately, yes.
And what are you trying to show in Defense Exhibit 6?
My knees, they were really inflamed and they were just swollen. The one on the right was more than the one on the left, but they were both swollen.
And just to refresh the court's recollection, when you were thrown or pushed to the ground, you were face forward, correct?
Correct.
And Defense Exhibit 7, is that one of the bruises that was on your leg?
Yes, that was also another bruise on my leg.
Now let me skip to Defense Exhibit 9. This was just, again, a picture from the day after you were booked, correct?
Correct.
Now, Defense Exhibit 8, when did you have this picture taken?
a week after, an actual whole week.
And
Just
did you experience significant bruising and injury to your elbow from the assault?
yeah, it hurt for a while, especially when it got cold.
For how long you remember? About how long did that that bruise stay on your body?
Oh, that one stayed for about a good close to 3 weeks, maybe 2.5 weeks, but it was there for a good while.
Did you ever experience, or I'm sorry, did you ever get intense swelling from this injury?
That one, yes. For the whole first week, yeah, it was bad. It was really, like, it just looked like I've been working out, but no, it was like a balloon for a while.
And but you never got it checked afterwards?
No.
Does it still bother you to this day?
Only when it gets cold. If anything, I can feel some pain on my left. But mainly my knees, though. I can definitely feel them in my knees.
And how old are you, sir?
I'm 28.
Okay. Did you ever play any sports or anything like that?
Objection,
Yes,
relevance.
It would be my next question, Your Honor.
Yes, I swim.
Okay, hang on.
I have some reluctance, but I'll overrule that. Go ahead, Ms. Gonzalez.
Okay. Is it fair to say the pain that you're still experiencing is from the assault on September 16th?
Yes, and it's really in my knees. Like I can't swim properly like I used to. I can't do my favorite stroke anymore because of my knees. Like I don't know. I know that after that day, they lock up a lot. They lock up, especially when I'm on my knees, when I'm working and stuff.
Now, you heard Devon testify, and you heard him say that the only reason he's allowed to leave the property is if he sees a felony or he sees somebody's immediate life is threatened and endangered. Do you remember hearing that?
Yes.
Is that the way that you felt that night before you got into your car to drive?
I felt that the whole way home.
Now, after Officer Zimmerman arrested you, you were taken into a room to take the breath test, correct?
Correct.
What were you feeling physically at that time?
Objection, relevance.
Your Honor, it goes to his injuries and what he actually said to Officer Zimmerman about the assault.
If I may respond, Your Honor.
Please do.
Mr. Sanchez's internal emotional state does not have, to my mind, a clear relevant connection to the physical injuries that he experienced at the time. We've already heard significant testimony and exhibits about the injuries that he sustained. It doesn't seem to me that his subjective emotional state adds additional information that is useful to the fact finder.
And Your Honor, then if I may respond by clarifying, I was not asking about my client's emotional state. I was actually asking him about what he was feeling physically from the pain, for what he expressed to Officer Zimmerman, which would also contradict what Officer Zimmerman testified to when he just took the stand.
I'll overrule the objection only to protect the record, but I'd like for you to wrap this up as quickly as you can with giving due regard to protecting your client.
Yes, Your Honor. Now, were you feeling physical pain when you were in that room with Officer Zimmerman?
Yes, I remember telling him that I couldn't breathe right because everything was hurting, and I even told him repeatedly, like, I'm pretty sure I have a concussion. I'm pretty sure I have a concussion. I have a concussion. I kept telling him that. I remember specifically at that moment, I kept telling him, hey man, like, I don't feel good. I need to see a doctor. And And then he told me like, no, well, you refused it earlier. But I was just telling him like, I mean, you can see on my head, it was pretty bad. I kept telling him I have a concussion.
Okay. Now, do you remember telling Officer Zimmerman when you were in that room that you felt that you were being followed on that night when you were driving?
Yes, I told him that I felt like there were people following me
Okay.
the whole way home.
All right. Thank you. I'll pass the witness.
May I proceed, Your Honor?
Yes, sir.
Mr. Sanchez, when
Yes.
Officer Zimmerman detained you and asked you how much you had to drink tonight, do you remember what your answer was?
From
The
seeing the
first-
video, no. I honestly, I was focused on just getting home. Like, I at that moment, I didn't even think I was going to get arrested because I was just my whole mind was home, safety.
So on the video, it showed that your answer was that you consumed 1 beer. Is that correct?
Correct.
That wasn't true, was it?
No.
And then further on, during Officer Zimmerman's investigation, you went on to claim that you had consumed no alcohol. Isn't that correct?
From the video, that's what I had said, but that wasn't true.
Now, at the time of the assault, did you remember the circumstances by which you were extricated?
I don't know what that means.
My apologies. Do you remember the circumstances by which you were assisted or saved?
Yes, I remember. I mean, I just remember. Well, I remember being there. I don't know. Can you repeat it again? I'm a little lost on it.
Let me see if I can ask this question clearly.
Please.
You remember being assaulted, correct?
Oh, okay. Thank you. Yes, I do.
Do you remember what brought the assault to an end?
No, I don't.
Do you remember your assailants fleeing?
I remember. I remember myself fleeing for some miraculous reason. I didn't. I thought they were. I thought they were after me for some reason. I
And
thought they were after me.
when the assault ended, did you see anyone else in the vicinity, anyone else around you who was not assaulting you?
Honestly, I just pretty much saw my truck, and that's the only thing I was focused on. My truck was honestly about maybe 50 meters away from me.
So your truck was convenient, wasn't it?
Well, after that happened, I just wanted to get to safety, and the only way I can get to safety was to get home, and the only means to get home was my transportation I took there that night.
You got in your truck. Did you call anyone?
No, not that moment.
After you started driving, did you call anyone?
It was closer. I was like right after the police officer put his lights on. I called somebody.
Who were you calling?
My parents.
Before you got into your truck, did you try to get anyone's attention to assist you?
No, I was just scared out of my life because it was just something. Just like it happened out of thin air. It was insane.
Approximately, if you remember, how far did you drive?
I'm only about like 10 minutes away from St. Mary's, I think.
Now, I apologize. Please continue your thought.
No, I just drove home. I mean, to where I remember getting there, home. I just knew where I lived. I went.
Did you actually see anyone following you?
I thought everyone was trying to attack me. I thought every car, anybody who was around me was someone who was attacking me. I thought anybody. In my knowledge,
Your Honor.
everybody.
Objection, Your Honor, non-responsive. I didn't ask how he felt. I asked what he perceived.
Well, yes, I thought they were behind me.
Hold up. When there's an objection made, you have to wait till I allow the question or I reject it.
My apologies.
Right. Technically, you asked if he saw anyone. So I'll sustain the objection on the question, on the response, rather.
So, Mr. Sanchez, I'll ask again. Did you see anyone following you?
Yes,
You saw people following you.
yes, in my mind, yes.
Did you see anyone following you with your eyes?
I'm telling you, every car I saw, I thought they were following me.
Did you see anyone following you from the time the assault ended to the time that you got into the vehicle?
Every time I looked behind the river mirror, I thought that car was following me.
So you thought that every car on the road behind you was following you?
Because I just got attacked by some like a variety of people, and I'm pretty sure one of them was gonna come behind me and just finish what he started. That's what I thought.
But you didn't think to call the police during this time, did you?
When it's a flight or fight response, mine was to flee, and my first thought was safety and home with safety.
So your fight or flight response kicked in and your first phone call was to your parents, not to the authorities to assist you?
I was actually calling them after the lights turned on me. I was like, I just told Siri or Bixby to call my parents. As there's a button for Bixby, just Bixby call my parents, and I was, hey, I'm getting pulled over. And that's how they knew.
And your fight or flight response didn't prevent you from lying to Officer Zimmerman, did it?
Running to him?
Lying to him about the amount of alcohol you consumed that night.
At that moment, like I said, I was just trying to get home.
Objection, non-responsive.
Anything further?
Your Honor, I lodged an objection to Mr. Sanchez's response as being non-responsive.
I'm sorry, I didn't notice.
That's all right, sir. May I repeat the question?
Yes, please.
Mr. Sanchez, your fight or flight response didn't prevent you from lying to Officer Zimmerman, did it?
No.
Your fight or flight response didn't stop you from impeding his investigation, did it?
I mean, I was impaired. I was impaired. So
Objection, non-responsive.
I'm going to overrule that. It's a response as he perceives it.
So in your impaired flight or fight response, you had the presence of mind to lie to Officer Zimmerman, didn't you?
I'm going to object, Your Honor. I believe that lying is a mischaracterization of what my client was trying to do. There is the possibility that he simply could have been, which he has admitted, that he was intoxicated and confused about what was going on. So characterizing it as lying is unfair.
If he does not understand the question or the preciseness of the language, then he can feel free to say, I don't understand. But absent that, it's up to him to say yes or no, or whatever response he thinks is appropriate. The interpretation of it partly is his and very much importantly is mine. You may answer the question, sir, if you're able to.
may you repeat it one more time?
Ms. Rivera, would you repeat the question for the gentleman?
Can you repeat the question one more time, please?
Yes, I will.
She's gonna read it. She's gonna read it
Okay.
to you exactly how he asked it, okay?
Yes, sir.
Your fight or flight response didn't stop you from impeding his investigation, did it?
No.
Your fight or flight response didn't stop you from refusing his offers to call EMS, did it?
At one point, I was saying yes, but in my head, I don't have insurance, so I had to say no because that's going to come out of my bill. I mean, that's what was coming in my head. So I said no. I said no.
So you were impaired and your fight or flight response consumed your mind, but you still had the presence of mind to think about your financial situation?
I mean, that's just how adrenaline works sometimes for some people. I mean, I was just a million thoughts going in one place, and just safety is the first one. And then I'm over here thinking, I got to go to the hospital. And man, you know what, when, I don't know, I just ran with the idea of a hospital, bills. I'm like, I can't pay for bills. I mean, that's just something that comes, I wasn't thinking about that moment, but when he said hospital, it came to mind. Hospital, bills, I can't pay for that.
And when he asked you if you wanted to file a police report, what was going through your mind that made you refuse to accept that offer?
I don't know who they were. I mean, I didn't get a visual face. That's why I really couldn't tell him what they look like, how they, or what color, or scarred or tattoos, because I really didn't get a good look at them. So, but I did tell him where it happened, and you know, I wasn't lying about anything other than, I mean, just about me not drinking. I was just scared to tell him I was drinking and driving drinking and under the influence, I'm sorry. That's why I was lying to him by saying no to his, because I was afraid to not being able to go home.
So you had the presence of mind to lie in order to get yourself out of trouble. Isn't that correct?
I think everybody does that when they're scared, yes.
And so even when Officer Zimmerman offered you the opportunity to make a police report, you declined that, didn't you?
I did, because I really don't know how that would go about if I don't even know how they look. But it just felt like they knew me, though. Because I don't think anybody does that to anybody on the street unless they know them. It was insane.
When you got into your vehicle, you didn't call any of your friends, did you?
I was more focused on the road. I was just focused on just not trying to be here on my phone and doing multiple things when when I already know I'm intoxicated. So.
Nothing further, Your Honor. Ask the witness.
Ms. Gonzalez, anything further?
Super brief, Your Honor. Christopher, you said that when you were driving, you felt like you were being followed.
Yes.
Okay, why did you feel like that?
Because the people who did it to me were random, and I thought they were not random to me, but maybe not, not them the other way around. I just felt like it was just, I thought it felt like they had a person vendetta against me. That's how, because it was just such a horrible event. That's what was coming in. That's what I thought.
Okay, let me ask you this. You said multiple times you didn't know exactly who had attacked you that night, right?
Correct.
Okay, so is it fair to say that in your mind, anybody that you saw on the road that you didn't know, like personally your family, could have been the people that attacked you, correct?
Correct. That's exactly what's going in my head.
So that's what was going on in your head at the time you were operating your vehicle while intoxicated.
Correct.
I'll pass the witness.
You were afraid. You were afraid that anybody could have been following you, weren't you?
Correct. Yes.
But you weren't so afraid that you actually called anyone for help.
Like I said, I didn't want to be on my phone and driving, and my house is honestly, to me, wasn't that far. So trying to be on your phone and be driving, and that's just, I was more of on just get home.
Nothing further, Your Honor.
Anything else, Ms. Gonzalez?
Nothing further. My client stepped down from the witness stand.
Yes, he may sit down from the witness chair.
I'm sorry. That was habit. If he can put himself on mute, so that way we know that he's no longer testifying.
All right. Next witness, Ms. Gonzalez.
Your Honor, this defense rests.
All right. State closes,
State rests and closes.
and Ms. Gonzalez, you close.
Defense rests and closes, Your Honor.
All right. Final argument, Mr. Edelman, if any.
Well, I believe Ms. Gonzalez opens the final argument. Since the state has the burden of proof, the state gets the last word.
And I would agree with that, Your Honor. But can I ask the court for a 10-minute recess to be able to stand up and stretch my legs and prepare my virtual courtroom for the arguments?
Yes, ma'am.
Thank you, Your Honor.
So a 10-minute break, Judge?
Yes, ma'am.
Okay, thank you.
Thank you. All right. You ready to proceed, Ms. Gonzalez? You're muted.
Yes, Your Honor.
All right. We got everybody. Go ahead, Ms. Gonzalez. I'm listening.
Thank you, Your Honor. Your Honor, as I addressed to the court after we took our lunch recess, the question before the court is not going to be whether or not my client was intoxicated. As the case law requires, my client has taken the stand and he does admit to each and every one of the elements for the offense of driving while intoxicated. The question before the court was why he was in the position to drive that evening. Devon Rusher answered that question to this court in the most succinct way possible. He stated that he could only leave the property, which he said he left the property and took action, but he could only leave his job site if there was an immediate life-threatening danger. From what Devon saw that evening of an assault, he believed that there was an immediate life-threatening danger. And that is what my client has described to the court today. And that is exactly the same as what he described to Officer Zimmerman, albeit in a very jumbled and confusing manner. However, as I stated, my client admits he was intoxicated on that evening. And as the court is well aware, and everybody that's watching and my client has learned from the definition of intoxication, and Officer Zimmerman testified to, the intoxication includes the normal use of a person's mental faculties. So by the state saying that my client didn't make sense that night, he's already admitted he lost the normal use of his mental faculties. So what we have to look at is that why. Now, Your Honor, if I may, we used to call it a PowerPoint. It's now doing a screen share for my closing. May I proceed?
Yes, ma'am.
Your Honor, this is taken directly from the Texas Penal Code. Title II, General Principles of Criminal Responsibility, Chapter 9. Under Chapter 9, Subchapter A, 9.22 specifically describes the conduct is justified if the actor reasonably believes that the conduct is immediately necessary to avoid an imminent harm. Number 2, the desirability and urgency of avoiding the harm clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the conduct. And 3, a legislative purpose to exclude the justification claimed for the conduct does not otherwise plainly appear. Now, for simplicity arguments, Your Honor, I believe it is clear that there is no legislative exclusion for my client being able to use the defense of necessity in the charge of driving while intoxicated. There is a lot of case law out there that specifically allows for this defense. And furthermore, there is nothing in the Texas Penal Code that says my client is not allowed to use this. So under number 3, that prong of this section has already been established. Now, under number 1, this is where it breaks off into several different things that the court needs to consider. It's going to come from my client's perspective, whether or not he reasonably believed that the conduct was immediately necessary. Now, when you look at immediately necessary, the Texas courts of appeals have gone into this fact in several different cases. And I found multiple cases, but there were actually 2 cases that specifically addressed this concern. And it was having to do with whether or not it was immediately necessary. Through the testimony of my client, through the testimony of Devon, and through the testimony of Officer Zimmerman, I believe, and my client is arguing, that it was immediately necessary for him to get into his vehicle in order to avoid that imminent harm. The harm, as my client described, it didn't happen the day before. It didn't even happen hours before. From what Devon had testified to, that when that the assault was actually happening, the life-threatening assault that was happening, the bouncer sprayed the pepper spray. Everybody dispersed, and that is where my client picks up the story of saying that, yes, he did get into his vehicle, the assault just happened, and he was driving away. Then the story continues with Officer Zimmerman stopping my client's vehicle, and the video clearly shows what my client saying, I was in a fight, I was attacked. He first says he was assaulted by one guy, he then says somebody was holding him down. It goes on and on. However, Devon specifically said it wasn't just one person. It wasn't just my client had several people to be able to help him. It appeared to Devon that there was 4 to 5 guys that were attacking one guy. The one guy that he saw during the attack, he wasn't able to identify my client. I do admit that. But I don't think that there's any question that the fight that Devon had helped that person is the fight that my client had been in that night and what he experienced during that attack. Now, is there a possibility that there were multiple different fights? It's always possible. However, the question now becomes up to the state of Texas, where the burden of proof now shifts back to the state of Texas to be able to prove beyond a reasonable doubt that there was another fight, that there was something else that had happened, and that Christopher Sanchez was not attacked. And I don't believe that they have met that burden of proof. Now, stopping my screen share to go to this evidence of the imminent harm, and the actual harm is going to be Defense Exhibits 1 through 9, Your Honor. Defense Exhibits 1 through 9 show not just one punch, not just one push, not just one kick. It is multiple injuries, a busted lip, several injuries to his head. I apologize. I pressed the button too many times. Busted lip, multiple contusions to his head, injuries to his elbow from where he fell, injuries to his knees from where he fell, which he also described through his testimony, bruises, and then a significant injury to his elbow. Your Honor, this harm wasn't make-believe. It wasn't just something he's coming up with now to get out of a DWI. He told this to Officer Zimmerman, who did not do anything to follow up on these allegations. Was my client confused? Did he not give as much information at that time? Sure. But does that prevent an officer from investigating something? When the officer sees quite plainly and clearly that my client was assaulted, and remember, Officer Zimmerman, he testified to this court and he said on the video, I can see you were assaulted. I can see you have injuries. My client told him what bar he was in. My client told him where this assault happened. My client, the officer testified, and you can hear it on the video, the officer had a radio where all he had to do was push that button to the dispatch and tell dispatch what was out there, what was going on. All it took was officers that were in that scene go over there, see if there were additional witnesses, see if there was anybody that saw this assault. But that wasn't done. And that is something that is required of an officer when they're investigating a case. When the officer is investigating a case, their sworn duty is to protect and serve the community. It is not just to build a case to charge a person. That officer had a duty to continue the investigation, and it also coincides with this DWI that he was there to investigate. Whether or not my client had a valid defense, even though Officer Zimmerman, he got it wrong. He does not know what is required of the defenses that are afforded to a person that is charged with a criminal offense. There is no duty to retreat. There is no duty to go a different direction. If you look at that penal code, it specifically lays out what is required. And none of those things that Officer Zimmerman was expecting of my client is required. under our prevailing case law and codes. So with those questions, the only question left to the court is whether or not the state of Texas has gone to their burden of proof to show that my client's use of necessity on that night was not justified. Is this not reasonable? And Your Honor, I argue to the court, the state has failed to rise to the level of their burden of proof. They had the information at the time that my client was arrested. Anybody could have gone back to be able to do that and continue that investigation. Furthermore, my client admitted on the stand today that he has previously testified to this information. And by the court's record, it'll show that that testimony was given in June of 2020. In that testimony, my client gave the two names that he stated today, with those two names being Hoel and Stevie. Those were his friends that were there that night. The state had that information in June of 2020. They could have contacted those witnesses. They could have presented that information to the court. They could have presented anything else to the court to be able to show that the life-threatening danger of the fight that took Devon Rusher off of his job property was the same one that my client has described to the court today. We have met the burden of the necessity, and we are asking that my client be found not guilty for the offense of driving while intoxicated for the fact that he was justified in driving his vehicle that day to be able to escape an immediate risk that he perceived and was actual on that day. Thank you, Your Honor.
Thank you, Ms. Gonzalez. Mr. Edelman.
Thank you, Your Honor. May it please the court. I have a certain amount of sympathy for Mr. Sanchez. It's clear that his injuries were significant, and that's probably an understatement. But we're not here to make our decisions based on sympathy. We're here to make them on the law. And plain fact of the matter is that Mr. Sanchez has not met the elements of the necessity defense that would entitle him to a not guilty verdict. So let's go through them sequentially. Conduct is justified if the actor reasonably believes. So let's talk about whether Mr. Sanchez had a reasonable belief. As I stated earlier, it's clear that Mr. Sanchez's injuries were significant. It's also clear that when Mr. Sanchez found himself in a bit of trouble, he had enough mental fortitude to be able to deceive the officer who detained and investigated him in an attempt to get out of that trouble. So the intoxication, the impairment that Ms. Gonzalez points to is a really funny sort of impairment because it's an impairment that only affects Mr. Sanchez's mental abilities to the extent that he believes that he needs to escape from physical danger, but not to the extent that he needs to escape from legal danger. Reasonably believes the conduct is immediately necessary. So was Mr. Sanchez's actions immediately necessary? Was it necessary for him to turn the ignition of that vehicle and to start driving it away? Well, Mr. Sanchez has testified that he certainly believed and felt that people were following him, that his assailants were following him. Unfortunately, the defense has not produced any evidence that anybody actually was following him. Once Mr. Rusher, if I'm pronouncing his name correctly, dispersed Mr. Sanchez's assailants, the only testimony on that matter was his, and he stated that none of them returned. So was it immediately necessary for Mr. Sanchez to turn the ignition on that vehicle and to start driving home to avoid imminent harm? And again, we're going to return to the testimony of Mr. Roucher. Once he dispersed those assailants, his uncontroverted testimony was that nobody returned. The assault was over. Mr. Sanchez may not remember it, but his lack of memory is not something that will significantly contradict the recollection of Mr. Roucher. Mr. Sanchez obviously and clearly suffered harm. But did he reasonably believe that his conduct was immediately necessary to avoid imminent harm? Absent testimony that he actually was being followed, that he saw people following him, that somebody else saw people following him, there is no further evidence that any further harm was imminent at the time that he decided to engage in the particular conduct that gives rise to this offense. Now, the desirability and urgency of avoiding the harm clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the conduct. I don't think we need to have a very long lecture about the social harm of intoxicated motor vehicle operation. Since the assault had come to an end, what urgency was there that actually existed? What harm was he now avoiding that clearly outweighed, according to ordinary standards of reasonableness, the harm that he sought to prevent by engaging in the prescribed conduct? Unfortunately, Mr. Sanchez's evidence does not rise to a level that triggers this prong of the necessity defense. And for all of these reasons, the court should not be swayed by it. I'm sure the court feels similarly to me that the harm inflicted on Mr. Sanchez was egregious, but he had an opportunity to pursue his assailants under the law. He chose not to avail himself of it. He chose instead to impede the officer who might have assisted him. Since the defense does not raise evidence sufficient to trigger the defense of necessity, the court should reject it, and it should find him guilty.
Anything further, Mr. Edelman?
Nothing further, sir.
Ms. Gonzalez?
I think if I were to speak, Mr. Edelman would have a very valid argument against it. So I have nothing further, Your Honor.
All right. I have a couple of items that I'm going to need to clear up for myself. Ms. Gonzalez, are you saying that I can agree with you when he first got in the vehicle to escape the immediate danger, the imminent danger? Had he been driving 30 minutes later, was he still in imminent danger only because he says he was fearful?
Your Honor, I believe the testimony that my client provided to the court does support the idea that he felt that he was still in immediate life-threatening danger from these assailants. And Your Honor, additionally, I can point the court to two specific cases for driving while intoxicated where necessity did play a role in the court's decision. However, these cases would be distinguishable from the case at hand for several reasons. One, obviously, they do not come from our jurisdiction, and they are just courts of appeals, not Texas Criminal Court of Appeals. So they are not controlling. However, the question before these courts was specifically addressing driving while intoxicated and whether or not it was immediately necessary. Now, in both of the cases, the courts did find that the trial court had properly rejected the inclusion of a necessity defense as the fact that it was not immediately necessary. However, in both cases, it was evident from the facts produced at trial that the driving had specifically continued past the point of the danger, which is different from what my client has testified to. My client has testified very clearly that he believed the the danger was still ongoing. That is further supported by Officer Zimmerman's testimony that my client was stopped at approximately 2:30 to 2:46, I believe is what is on the video and the police report. And it's corroborated by Devon Rusher, who is saying that he got off work around 2:30, and the fight had happened right around that time. So it does appear, by adding the facts all together, coupled with my client specifically testifying that he felt he was still in danger, that the danger was ongoing.
All right. Well, I'm going to find the gentleman guilty. I'm not satisfied that the defense of necessity fully applies. To rule otherwise, in my mind, would just invite anyone and everyone to testify that they felt they were in danger. I readily recognize that Mr. Sanchez had been assaulted. It was a serious assault. I also recognize that with a 0.021, 0.21, I can't help but wonder in my mind, what was he going to do absent the assault? But I understand that's a separate issue from the defense of necessity. Was it reasonable for him to be panicked at the time that the fight was broken up? I don't know if he had a continuing imminent danger under the reasonableness effort or idea. I don't buy that at this point. To me, it exceeds the reasonableness idea. I don't question that he was attacked. But once the attack was over, I don't see that as an imminent danger, therefore, forward. He testifies, as we know, that he felt that he was being followed. I don't find that credible, and I'm sorry, but I don't. So because of that, I find him guilty. Now, do y'all want to proceed today with the elements of punishment, or you want to prepare for that, do it some other day?
I don't know about the state, but I'm ready to proceed to punishment today. We are going, obviously, because there's no jury, we are going to the court for punishment.
I suspected that you would if that happens.
Your Honor, the state would request a reset for a punishment proceeding because, unfortunately, circumstances prevent us from gathering in the same place to be able to take Mr. Sanchez's fingerprints, to be able to prove up the prior conviction that we allege he has in his past.
Okay.
Your Honor, may I address that briefly?
Sure.
In order to save time, since this obviously has been delayed for a while now,
Yes.
we will stipulate to the prior conviction. So that way we can proceed today, and then I would be able to file my notice of appeal and withdraw and have an appellate attorney appointed.
Alrighty. Very good. With that stipulation, Mr. Edelman, are y'all ready to proceed?
Yes, Your Honor.
All right. Mr. Edelman.
In light of the length of time that Mr. Sanchez has waited for this case to be adjudicated, I think that a shorter probationary period is warranted. First of all, I think probation is warranted to begin with, in part because I believe that probation in general is a superior option to confinement in most circumstances. And I prefer to give a person an opportunity to show the court that they cannot abide by those requirements, rather than to assume that they constitute such a danger to the public that they need to be sequestered away from it. I would recommend a length of supervision in the range of 14 to 16 months. I would not recommend a fine, even a probated one, because it seems to me evident that Mr. Sanchez is indigent. I would recommend the DWI intervention class, the victim impact panel live. I would recommend something on the order of 60 hours of community service, a TAP evaluation. And unfortunately, I believe the law requires that upon conviction of an offense such as this, that there be a minimum term of confinement as a condition of supervision. I believe that length of time would be 3 days for 72 continuous hours. I would recommend that the court allow Mr. Sanchez to serve those continuous hours on house arrest, I should say.
Anything further?
No, Your Honor.
May I respond, Your Honor?
Of course you may.
Thank you, Your Honor. With regards to the 3 days at Bexar County Jail, I would need to get the information from either Mr. Courtois or Ms. Garcia as to how many days he actually has in custody to see if that has already been satisfied. If not, I would ask that we hold this in abeyance, simply because, well, actually several different reasons. Having him go to Bexar County Jail right now during a COVID pandemic is going to put his health in serious risk. Furthermore, I believe the system is already well overrun right now in Bexar County Jail. 3 days is a drop in the bucket. Furthermore, the court has notified me through chat that has notified everybody that my client already has 6 days in custody. So I would ask that that be used to satisfy that requirement. From what else is being recommended by the district attorney's office, because my client has already been on probation, on pretrial supervision for over 2 years, I would actually ask for a little bit less time. I know that this particular length is less than what they would offer had we taken a plea. However, like I said, my client has been waiting for over 2 years to be able to get to the point for trials, and he has been supervised by probation, has not committed any new offenses. Yes, there have been concerns and questions about whether or not he's violated some of those conditions, but he's always stepped up. He's always received the additional alcohol monitoring that was required by the court. So I would ask for a little bit of grace and lower sentence for the length of probation. But I believe the classes are what are required by the penal code with regards to a DWI conviction, and everything else I have no objection to.
And Your Honor, may I briefly respond?
Yes, you may.
Mr. Courtois informs me that Mr. Sanchez has served 5 consecutive days. And so the 72 hours of consecutive confinement would seem to be satisfied if the court will apply those days towards that requirement. Additionally, and I forgot to mention it earlier, but I believe that upon a second conviction for DWI, ignition interlock, or some form of alternative is a requirement, that it is not discretionary with the court. I may be wrong about that, but that seems to be my recollection.
And Your Honor, may I respond to that?
Yes, you may.
From my prior research, we had addressed this issue at our last hearing for the speedy trial with regards to specifically ignition interlock. And the court had made the finding at that point in time, in the interest of justice, all of the alcohol monitoring was waived for pretrial. When I did that research, I do believe that it was also, as it can be done when a person has been convicted. So I would ask, because of all of the prior expenses that he's made with regards to ignition interlock, at one point he was on antabuse pills and then also scram monitoring. That was significant cost to him. So I would ask that the court similarly find that it can be waived out of the interest of justice.
All right. I have some questions for you, Mr. Sanchez. You'll need to unmute. Mr. Sanchez, how are you employed right now?
I do subcontracting of tile.
Sorry?
I get contracted to do tile. I do tile, showers, floors, backsplash.
Right. How much do you make monthly?
Well, I don't work every day of the week. Sometimes roughly about 1,500, close to 2,000 if I'm lucky.
All right. And do you have any dependents?
Meaning who do I take care of?
Sure.
Myself, and I do have a girlfriend that I do help out.
Or do you help your parents?
Yes, yes, I do as well.
All right. The statutes in Texas require that on a conviction for a DWI second, I think there's approximately a $5,000 fine, Mr. Edelman, is that correct?
Yes, but I believe that is upon the actual imposition of a sentence.
Okay, that means no probation. All right. I do grant you probation. Just in order to protect the record and protect you, I find that you are indigent and unable to pay the state's fine upon a conviction. Now, you were sentenced to 12 months Bexar County Jail, probated for 12 months. You will participate in and complete the DWI intervention program. Your supervision, does anyone know when his last violation was on his pretrial?
I do not know that, sir.
Your Honor, if you can give me a moment, if these pretrial services, they do sometimes send me reports. I may have the latest one. If you can give me one moment.
Okay.
Oh, let's see. The only report I have is dated April 15, 2020, and it is stated as the 5th violation report. It was failure to enroll in anabuse. Not in. It says. I'm sorry, Your Honor.
5.
Hinkle.
Mr. Sanchez, have you had any further violations reported since then? Do you know?
No, Your Honor, I haven't.
Okay.
Ever since you got on me, I made sure not to.
All right.
Judge, if I may, just upon reviewing the court's records, it appears that the last one was on April 15th, 2020.
Okay. You've had almost a year without screwing up any or allegedly violating. That's good. I'm glad to hear that. Mr. Edelman, go down your list. I know I'm going to order you to do 60 hours of community service restitution. The supervisory fee will be $25 a month, which is the minimum. You'll participate in a TAP evaluation and the recommendations. The DWI, well, I think if we do the intervention, we don't do the education. Is that correct?
That's correct, sir.
But we do the victim impact panel.
The live version of the victim impact panel, sir.
Sorry.
The live version of the victim.
I'm not going to recommend live right now because of the pandemic.
I was thinking the same thing, Your Honor.
All right. What else we got?
What the court's final ruling with regards to a fine, I know the court said that my client is indigent, but then also the 3 days of continuous confinement.
The 3 days continuous confinement, the court gives him credit for time served, which he has already done 5 continuous days. So the court finds that that is satisfied. What else?
With the indigency finding, is the court going along with the state's agreement of a $0 fine?
I will, Mr. Sanchez, with some reluctance, but I'm hopeful that you have turned a new page and will not be drinking and driving. One of my greatest concerns in hearing this case was that, you know, a 0.21 is more than 2.5 times the legal limit. And even if there had not been an assault, you know, there's no doubt in my mind you were going to get in that truck and drive off. That's my belief from the evidence and what was going on. So I hope that in an effort to be somewhat fair with you, I'm not making the mistake of putting you out on the street where you will constitute a danger, not only to yourself, but your loved ones and the public, families and children. You read and hear all the time where people wind up getting killed by a, quote, drunk driver. And don't make any mistake, it's not drunk, it's intoxication, and that happens way before drunkenness. So, Ms. Gonzalez, I'm sure you've talked to him about that. I do want you to appear in the offices here of County Court number 5. You know where the court is. Around the back, there's a hallway, and you can find the offices for County Court 5. You'll be required to come in and place your, have the clerks help you place your thumbprint on the judgment and documents. When you're here, I want you to take 2 documents with you. One is one labeled or titled probation, and the other one is one that's titled intoxication. I want you to give me your word that you're going to read those carefully, especially the one that's titled intoxication. It tells you that intoxication is not drunk. It's way before you're drunk. You got to know that because this is your 2nd round. The 3rd one will get you state prison. And I hope you don't want any part of that. Do you understand?
I do, Your Honor.
All right.
And I thank you.
Anything else, Mr. Edelman, Ms. Gonzalez?
One note that Ms. Garcia just sent to everybody is that the application did not go through because of Christopher's email address. So we would just need to clear up with Christopher, which I can do after this, is to make sure that that application does get into the court's file.
Very good.
And Your Honor, I would like the court to act as though the application for probation had been turned in before the beginning of trial.
That was noted by Ms. Gonzalez that she was submitting, for purpose of the record, she was requesting probation for her client. I'll accept that as a part of the record. And she did not elect, but obviously she didn't need to elect. She did, although declare it for the record that she was coming to the court for punishment if one was necessary.
You know, that is a really good point that maybe for the future hearings, if we continue doing this process, we should add that to the jury waiver, that it's an automatic election to the bench, obviously, for punishment.
It may well be. All right. Anything else?
Yes, one further thing. Andrew, did you get the documents as signed and received for the packet that you'd sent out? Because that went from myself to Christopher. So I just want to follow that chain and make sure that it, those documents, because we use the same email.
Let me see. Do you mean the discovery acknowledgement?
Correct. It had a few different documents in there, but I think it was labeled discovery acknowledgement.
They were signed by Mr. Sanchez, and they are awaiting Judge Longoria's digital signature.
Okay, I just want to make sure it got past Mr. Sanchez. I will speak to Christopher after this to go over everything, and I'll make sure that that gets signed and returned back.
Now, Your Honor, I do have a few additional questions for Mr. Sanchez, if I'll be allowed by the court and by defense counsel.
You have my permission.
And I'll object if it's necessary. I don't know the questions right now, but.
I was just curious, Mr. Sanchez, do you care for any family members?
Yes.
Could you expand on that, please?
My mom, Maria Sanchez, Mario Sanchez, my mom, my dad, Mario Jr. Sanchez, Jacqueline, Kirkpatrick now, Kel Kirkpatrick.
Well, what I really meant was, do you care for any infirm or disabled members of your family on top of your full-time job that supports
my
yourself?
girlfriend. My girlfriend. She's very sick as well. She has a bunch of gastro issues. She's very, she's always weak. She's actually asleep right now.
All right, I only asked because I was curious if Mr. Sanchez was responsible for something like the home health care of a family member. And if that were the case, we might have that care work substituted for community service in certain instances. But I don't know if the
not by the
circumstance
state.
here.
Sorry.
No, please continue.
No, well, I mean, you're asking for someone who's like on who's sick and you take care of them, but they're like on record, right? Like someone who's being taken care of by the state, kind of, and they get someone to take care of them. Is that what you're saying?
Sort of, yeah.
I don't particularly take care of someone from the state, but I do take care of my girlfriend. She is really sick.
All right, I'm not sure that rises to the level of what I was thinking about, but I wouldn't know if I didn't inquire.
Okay, no, I don't.
That's all I wanted to ask.
No objections. Okay.
Anything else?
I'm sorry, Judge?
Anything else?
I have nothing further. If we're done with this part of everything, I'll just need to be placed into a breakout room with my client so that I can explain the next steps and see what it is that he'll want to do.
All right. Ms. Garcia, would you place them in breakout? Ms. Rivera, Mr. Courtois, and Mr. Edelman.
Yes, sir.
Y'all are all excused.
Thank you. Real quick, Kayleen, I uploaded.
Put this on the record?
No.
Can I go ahead and stop the YouTube?
Yeah.
Well,
Ma'am.
yes.